Good afternoon, everyone. Yes, I'm here again this week. I know I was here last week, but Gabe will be back next week. Um, so today I wanted to start out as I have the past couple weeks, just reminding you that Bond will be continue to host a breakfast briefing concerning, if you could turn the slide, Kathy, managing the struggling employee mental and emotional health in the workplace. We've already completed sessions at several upstate cities. Rochester's just finished up today, but plenty of more opportunities to come out and have a good discussion with us about a topic that I know all workplaces are dealing with these days. Moving on to today's agenda, I will give a brief update about a couple of laws recently signed by Governor Hochul that impact employers in New York State. Then we have an all downstate lineup. Beyond that, we're going to talk to Howard Miller down in Long Island about an interesting First Amendment and academic freedom case. Lou DiLorenzo is with us for some discipline and termination considerations. Always an interesting discussion with Lou. And then we have John Harris, who will talk about an employee benefits topic to round things out. So why don't we just jump right into it with my piece of the presentation. This shouldn't take too long. Perhaps in honor of Labor Day, Governor, and it's bill signing season in Albany, Governor Hochul did sign a couple of laws earlier this month that I think are worth mentioning to you. If you could flip the slide, Kathy, because they really are very broadly applicable. One involves a new notification requirement when employees leave employment and when they have a reduction of hours, so much so that they would become eligible for unemployment. The law basically just requires you to let people know of their eligibility so they don't forget to apply. Not sure if this is a solution for a problem that didn't exist, but here we have it. And we do anticipate that the Department of Labor will issue a form for this. The law says, quote, on a form furnished or approved by the department. So I believe they'll be issuing a form. The law is not effective until 60 days after signing, which would make it November 13th. We have a little bit of time. But, we've got people leaving employment on a regular basis all over the state. And so this is something that's just going to have to become part of your exit routine. So I wanted to make you aware. The other law I wanted to mention is going to relate to social media. If you could turn the slide, Kathy. So this law prohibits employers from requesting or requiring employees or candidates to turn over their username and login information and password as part of the job application process or as part of employment or part of a disciplinary process. Basically, what New York State is saying is if people are choosing to keep their online presence private, it should stay that way. They should not, as a condition of employment, have to tell their employer what their password is so that, the employer can log in and check out what they're doing in their private online world. Hopefully this is already not part of your process, the actual involuntary seeking of passwords. But if it is, this is something to be aware of. I did note on the slide a number of exceptions. So if someone has a online presence, social media site that's for business purposes, if they've already been put on notice, then you can access that account. If you've given them the electronic device, the laptop, the phone on which they use it, as long as you've given them the proper notices that the employer has the right to access that device, then you're okay. The employer applicant can voluntarily share information. And if stuff's already public, if someone has a Instagram page that's already public, you can certainly look at that. It's just if you're forcing them to make public something that otherwise would not be. This is not effective for a few months. It will become effective in March. And I'm sure that we will be here reminding you of that when it comes closer. But these were just two laws I thought were notable that Governor Hochul signed just a couple weeks ago. That's all I have. So I'll turn things next over to our presenter, Howard Miller, who will talk about this First Amendment case. Thanks, Howard, for being here today.
Good afternoon, everyone. So for those of you who are in the private sector, I want to try to make this a little bit relatable to you. There is this increasing trend, which we've seen for a long time, that whenever you fire an employee, no matter what they did, they will always say it's not their fault. It's the fault of their employer. So for example, I work for you, you catch me red-handed walking out the door with a cash register, you fire me and I turn around and I sue you. And I sue you for saying that the reasons you fired me were discriminatory, or I'm a whistleblower, or if I'm a public employee, I argue that you're really terminating me because I engaged in protected speech. An example of that, and kind of one that we really did have in our law firm, you had a situation where an employee gets into a quarrel with his supervisor. He storms out of the office and out of the building, goes to his car, opens the trunk, and takes out a machete, because after all, who does not keep a machete in the trunk of their car? And walks back into the building and chases his supervisor. Now, fortunately, no one was hurt with this incident, but as you can imagine, company tends to frown upon machete-wielding employees, and they terminated his employment. He brought suit claiming his termination was unlawful for a whole host of reasons. He lost that suit. It was not discriminatory, and wielding a machete is not speech protected by the First Amendment, at least not in New York, maybe in Texas or Florida, but in New York, it is certainly not, which leads us to what is protected by the First Amendment. And I think here, some of you may have seen a movie called The Princess Bride. And in that movie, a character keeps on using the word inconceivable. And finally, a character named Inigo Montoya says, I don't think that word means what you think it means. And the First Amendment is certainly not a get out of jail free card like people think it is. First of all, your speech, the employee's speech, must be in a capacity as a private citizen on a matter of public concern. So if I work in the county attorney's office, which is a public employer, and I go on my Facebook or Instagram account and I start talking about how my supervisor is the devil incarnate because he or she has the audacity to make me actually write briefs, that speech is not protected. That is my own private grievance. It is not a matter of public concern. And also another area of defense that is not protected speech is when an employee is speaking as part of their job responsibilities. And the leading case on that is a case called Garcetti versus Sabalos, and that went up to the United States Supreme Court. And in Garcetti, you had an assistant district attorney writing an internal memo expressing concerns about a particular prosecution. And the Supreme Court said that that internal memo was not speech, or was not protected speech, because it was just part of the job responsibilities of the district attorney to write that kind of a memo. So the memo, that speech, owed its very existence to the employment. Let's change the facts a little bit. Let's say the district attorney, instead of writing an internal memo about a specific prosecution he was working on, posted an op-ed piece in the New York Times about the fact that the criminal justice system is overburdened because we are not getting at the root causes of criminality, such as poverty. That speech would be protected speech. There, any private citizen could have made that same post. The speech did not owe its existence to the public employment. Other examples where we see employees losing First Amendment cases, I had one, for example, where an English department chair filed an internal complaint about a particular book being part of the curriculum. The court in that case said, well, that's your job as department chair to engage in that kind of discussion, so your speech is not protected. Now, of course, as the case law has evolved, we've seen more and more people try to say, well, what I was doing was really not part of my job responsibilities, and having a very minimalist approach to their jobs, and those type of efforts have been rejected by the courts. Anyone having trouble speaking tonight that wants some further information about that particular issue, I did write a blog article about this. It's entitled Lloyd Dobler's view of his job responsibilities. Lloyd Dobler is a character from a movie called Say Anything, and it connected quite well with this particular topic. So one issue that was left open by the Garcetti court was whether this whole concept of it being part of your job applied to academic freedom. That is, speech of a professor in the context of a classroom. And the Second Circuit ruled on this a few weeks ago. The case is called Heim versus Daniels. Now, in this case, you had Professor Heim, who is an adjunct professor at SUNY Albany. He taught economics, and he taught economics from a Keynesian model of economics. It seems that the powers that be at SUNY Albany disagreed with the Keynesian version and adopted another model that they thought was appropriate for instruction. Now, by coincidence, I happen to have studied economics at SUNY Albany. I was the guy in the back row of the lecture center with a pillow and a Slurpee, so I am not qualified to weigh in on who is wrong or right about what model is the best economic model to talk about. And the Second Circuit said neither are they. So the Second Circuit wasn't going to be there discussing who's right or wrong. But what the court said is the fact that there's this robust disagreement on what is the appropriate methodology, and given that colleges and universities are supposed to be a marketplace of ideas, we need to give academic freedom protection. And we're going to do that in this case. So classroom speech on a forward basis in the Second Circuit is entitled to free speech protection. But there's a caveat there. Just because the speech is entitled to First Amendment protection doesn't mean that the professor wins. And in fact, the professor lost. The reason why the professor lost is that the court said, notwithstanding academic freedom, a university has a right to determine what is appropriate scholarship, what merits being granted tenure. And here you had somebody who was applying for a tenure-bearing position. And because of that, the university is allowed to say its interest in teaching a certain method or adhering to a certain type of scholarship outweighs any First Amendment right for a professor to have a contrary view. Now, the court left open the possibility that somewhere down the road, a professor could win a claim by showing that his or her right to academic freedom trumps any disruption that the university may be able to articulate. So where might that be? I have a son who's studying international relations in a public university in the South. So let's say in the course of a classroom discussion, a professor is talking about the merits of the United States giving aid to Ukraine in the war. I would think if all the professor is doing is fostering a discussion about that, even if they're giving their own personal perspective, that's going to be protected speech, and that would win over any balancing interest on the part of the college. So our advice is that as we go forward, to the extent that a university is going to deny tenure or make any other adverse determination regarding an employee on the basis of scholarship or on academic freedom, that you consult with counsel first about whether that would withstand scrutiny, because that, again, this case was just handed down. We anticipate that there's going to be a whole legion of cases that are going to try to test the boundaries of this case. And we want to give you advice on the front end. For those of you who are online who may work at K through 12 schools, the court made clear its holding was only limited to higher education institutions. The Supreme Court in the Garcetti case also referenced higher education. There is a case being litigated now in court in the Eastern District of New York. It's called Schultz versus Comac School District. The Second Circuit in the high division, the court in that case seems to be suggesting that academic freedom does not apply in a K through 12 setting. By coincidence, I happen to be representing the district in that case. I also, by coincidence, happen to be an alumni of the school district. And because now I'm an alumni of both SUNY Albany, which is the defendant in a major case, an alumni of the Comac schools, which is a defendant in a major case. I did receive an email from my law school expressing concerns that I'm some sort of a jinx and that they will be next in line for a major case. So they asked for a sizable donation to the university. Now, as it were, I do some legal work for my law school. So if that happens, I hope they'll let me defend my own jinxiness to the extent that that's a word. But that is the holding in this case. It is a case of first impression. It is the first case in New York to hold that academic freedom applies to university, that the First Amendment applies to classroom speech of a university professor, and that the Garcetti defense is not applicable. So thank you.
Thanks, Howard. And your story of the machete just reminded me of a story that I think this audience would really appreciate. So just bear with me here. I was on a trip down south, and the kids knocked a coconut off the tree, and so went to the front desk and said, "Is there something we could have to open this? It would be kind of fun on vacation." And they came out with a machete. And I thought, if I was the manager of this hotel, I would have real concerns to my employees handing out machetes to our guests.
Yeah, where does one buy that? Do you just Amazon Prime and they'll get it to you the next morning? Like, how does that happen?
My lawyer brain was exploding at that point. So anyway, thank you so much.
Okay, thanks.
So up next, we have Lou DiLorenzo with us, who's going to talk about some just general discipline and termination considerations, things that we always just want to be reminded about in our workplaces. Thanks for being here, Lou.
Hey, Kristen, thanks for inviting me. And one of the reasons I'm particularly interested is for 2 years, I've been looking for a place to wear this shirt. And I think this is about the only place. So I'm delighted to be here. Howard, very interesting First Amendment analysis. So today I got about 10 minutes and maybe a little bit less if I can try to keep you on schedule. I thought it might be a good time. You can't talk about discipline and termination considerations enough. Some of the things that, I've been doing this almost 50 years, unfortunately, and I still run into the same things today that we ran into in the 70s and the 80s and the 90s that cause us and our clients a lot of heartburn in our cases. So first slide here, Kathy, thank you. So one of the issues is timing, right? And like Goldilocks, it's got to be just right? You can't delay it. Don't overcook it. I believe that there's a time for everybody to be hired, and unfortunately, there may be a time for people to be terminated. When that time comes, you have to recognize it. When you miss that opportunity, it never fails that we get a case where somebody is not performing well, but recently they got involved in perhaps trying to start a union, perhaps they were a whistleblower, perhaps they complained about discrimination, perhaps they were a witness against us. Something else happened in the meantime. And, 6 months ago when they were under the influence of alcohol or drugs on the job, or had engaged in theft or some misconduct or dishonesty, and the employer decided to give the person another chance. And then the protected activity comes, and now it becomes a very difficult situation to terminate them. So if you need to terminate somebody, then you should do that. So don't overcook it. If the hot dog's done, take it off the grill. At the same time, don't undercook it, right? We want to make sure that our termination case, and I'm going to talk to you about some of the steps you should keep in mind as you're evaluating whether someone should be terminated or whether we may have potential liability for doing that. But there's a timing issue here. Time and time again in our retaliation cases in federal court, I have district judges, when we move for summary judgment, saying, look, the fact that this episode occurred a month or two after they engaged in some protected activity, I have to deny the summary judgment motion because a jury could decide that the reason you took the action was because they had engaged in the protected activity. Sometimes we got a 2-year history, 10-year history of bad performance, and that's turned around and used against us because the plaintiff's lawyer argues, well, for a whole year, they were a bad employee. they allege, with all these warnings, all this discipline, but they never decided to fire the person until after they engaged in that protected activity. And that's what put them over the edge. That was the straw that broke the camel's back, not this last incident. So keep in mind timing. Next slide, please, Kathy. Be careful with references after you terminate somebody. You should have some kind of a policy that indicates you're going to give name, rank, and serial number kind of information out only. Make sure your supervisors and managers know that policy. What we frequently have happen is people call not to the HR office for a reference. They'll call the last person's supervisor and ask them to give a reference. And sometimes what happens is the supervisors and manager give a good reference on a good employee, which under New York law may destroy your ability to hide behind the policy that says its name, rank, and serial number, because if you violate that policy for good employees, then for bad employees that are currently suing you or have filed a complaint with the New York State Division of Human Rights, you're not going to be able to deny them that same benefit of employment, which is a reference. So have a policy, make sure it's enforced, make sure your supervisors and managers know to refer all references to HR. If I had a nickel for every supervisor or manager that gave a reference on somebody that caused us a problem, and some of the times they're recorded when they do this because it's people pretending to be a prospective employer on behalf of the former employee. If I had a nickel for every time they said, well, I just gave a personal reference. There's no such thing as a personal reference when you're a supervisor or manager if you work for my clients. Here's the policy. This is what you follow. Next slide, please, Kathy. So 7 steps of discipline. These 7 steps and 2 corollaries that I'm going to give you. The 7 steps come from, I think it's a 1946 arbitration decision by arbitrator Dougherty, a pretty famous arbitrator, post-World War II arbitrator. He wrote these in a decision. This is not the law. This is not contractually required, even in a labor arbitration, although I have seen some pro-employee and pro-labor arbitrators apply the 7 steps. But I think it's a great way to check your blood pressure and temperature to see how good your case is, see where the weaknesses are in your case, see where you might be able to make your case stronger before you hire the person, or at least know what you're vulnerable to going in as you assess the risks of firing somebody at this point in their career. Notice, did the employer give the employee forewarning or foreknowledge probable consequences of their conduct? Were they on a last chance agreement? Is it a policy? Is it something we have in our handbook? How do we prove that the employee knew or should have known that this conduct was prohibited? Some things are just so obvious. You don't need to. If you saw that movie, A Few Good Men, there's a scene where one of the officers is cross-examined about that policy concerning the orders that are given, and they were cross-examined about the manual for Marines at Guantanamo Bay, and on cross-examination, lawyer said, "Does the handbook? Do you get any meals at Quantico?" And the soldier said, 3 squares a day. And he said, "Well, there's nothing in the handbook about where did you go to eat?" And he said, "The mess hall." He said, "There's nothing in the handbook about 3 squares a day at the mess hall." And he said, "Well, we just know that, and it's not in the handbook." That's the same thing with certain things, right? You can't shoot your supervisor, and so on. I mean, there's some things that we got from the 10 Commandments, some things that we just know under our Judeo-Christian culture, and living in a civilized society you don't do. But short of those kinds of things, can we prove that the employee knew how this would be dealt with and that it was prohibited? Is the order or rule that they violated reasonable? We want to start out with, if we can, that this is for example, I had this case, dynamite plant. We have a rule: no tobacco products, no matches on premises. guys caught, and we do random searches at the time clock. A guy gets caught with matches in his socks. He's fired for a first offense. I go to arbitration and I argue that, this is Western civilization is endangered at this plant if somebody can bring matches in and incendiary devices. We had somebody die shortly before that arbitration where there was an explosion and 3 people died, unfortunately. So is it related to the business? How do I make the connection between why this is important and why the person deserves to be terminated for doing it? The best case we have is Western civilization is endangered if we allow it, and obviously they move away from there. Investigation, did we do a reasonable investigation to try to find out if the employee was guilty? And that would include get the employee's version of the events. Lay people have a high standard of what an investigation is. Jurors tend to think of investigations like what they see on television with, DNA evidence and other laboratory kinds of conditions. Want to make sure we do a good investigation. We talk to the relevant witnesses. We looked at what was relevant. We don't want any loose ends, even if we've got to run them down an alley. Even if we got information on video camera and you think you got it locked, do the investigation, including, next slide, please, Kathy, including making sure, number 4, that it was conducted fairly and objectively, and that includes getting the employee's version. When you confront an employee, that's always something you should do with the misconduct. 3 things can happen. The employee can agree with what you found. Did you steal this information? Did you start this fight? Are you guilty, basically? They can say yes. They can deny it and lie about it, which is also going to help you if you go forward and terminate the person. Or they're going to refuse to answer, maybe on Fifth Amendment grounds. And a private employer, they don't have any Fifth Amendment grounds to refuse to answer. They have an obligation under New York law, common law duty to cooperate in any workplace investigation. 5, did we obtain substantial evidence that they were guilty as charged? We don't have to prove that they're guilty, for example, to avoid a discrimination case. We do have to prove guilt if it's a just cause standard, such as under a labor contract. In the discrimination area, they have to prove that we intentionally discriminated. If we prove that we relied on an investigation, made a good faith judgment the person was guilty of misconduct, we don't technically have to prove that they committed the misconduct, just that in good faith we believe that, and we had a reasonable basis for doing so. Equal treatment, have we applied things even-handedly without discrimination? Appropriate discipline, did the punishment fit the crime? If it's a minor offense, if we engaged in progressive discipline, for example, to the point where it resulted in misconduct almost of an insubordination nature. We kept telling them not to do this. We engaged in progressive discipline, more serious discipline as things went on to show how serious we were, including what maybe a suspension or a last chance agreement before the termination. Next slide, please, Kat. So those are the 7 steps. Corollary is, like I said, these were adopted in 1946. Di Lorenzo, that's me. I've added 2 corollaries to those 7 steps. One is you should ask yourself another question. Is this employee entitled to reasonable accommodation for any reason, such as a disability or religion? In that case, it's not enough to show that there was no discrimination. We've got to show that either there was no reasonable accommodation requested or there was none that could be granted. But we want to explore that situation because reasonable accommodation goes beyond the non-discrimination obligation. It's an affirmative duty. Corollary number 2, next slide, Kathy. This is the protected activity one we talked about before. Has the employee engaged in any protected activity recently? The last 6 months, for example. Complained about wage and hour law, complained about some practice, complained about a whistleblower problem, engaged in protected activity under the National Labor Relations Act. If that's the case, we still may go forward with the termination, but we want to deal with that issue and go into it with our eyes open. Next slide, please, Kathy. Handbooks on termination considerations, you want to check their accuracy. You want to make sure we're describing the right things. This isn't, if you haven't updated the handbook in a couple of decades, it's a good time to do that. Make sure we're giving notice of what we're requiring of people and what we're relying on in terms of grounds of termination. And we reserve the appropriate management rights to do so. Hopefully employees are employed at will, so on. And we want to make sure we're in legal compliance with the NLRB recent decisions on handbook rules. Can't cover that today. Apologize, we don't have enough time. Next slide, please, Kathy. Settlement agreements. If you terminate somebody and using a settlement agreement, make sure you take a look at it. Make sure it's got all the best bells and whistles that are required. New York law, for example, has instituted a number of changes that apply to settlement agreements. You want to make sure they're still good. Don't dust off one that's 10 years old and say, you know, I don't think we need to do anything. We'll just change the names. Could be a big mistake on the enforceability of the agreement. We want to make sure you're paying money, we get a good release. Next slide, Kathy. We want to know your document retention policy, especially if we've got a case and we got to preserve documents. We want to look at your performance evaluation documents. The worst thing that happens is when we walk into a case in a federal court and the judge says, you know, the plaintiff's lawyer talk about somebody working for the last 20 years that we fired. And the first thing these judges ask and arbitrators ask is, what do the performance evaluations look like? If it's a performance issue, we may have to overcome those documents. My experience is supervisors try to be nice to everybody. They overgrade everybody, and the evaluations don't match up with what's going on with the performance. They got to be done honestly. You want to put that in as good a shape as you can before the termination decision. Obviously, review termination documents for compliance as well. I think that's it, Kathy, isn't it? Is there one more? Oh, just overtime wage and hour issues. We get into terminations and plaintiffs' lawyers try to leverage wage and hour issues that can come up. Next slide, please. Can't train your supervisors enough on discrimination issues. This discipline philosophy, for example, if you've got a union philosophy, if you're interested in remaining union-free in light of the recent decisions, you want to cover that in your training. How to handle internal complaints, maybe make sure those get elevated up and handled properly. And they understand their role in the organization, how important they are, because they are the face of your organization. Next slide, Kathy. I think that's it. John, good luck. Sorry, I went a little bit over. Thanks.
No, actually, Lou, you're right on time.
Okay.
Yeah, you're fine.
I don't think
You
so.
got no, you're good.
Good
Got
luck,
10 more
John.
minutes. All right.
Thanks.
Thanks for being with us, Lou.
Okay.
So we've got John Harris from our New York City office. And I won't try to interpret this title, but I know it has something to do with employee benefits. So thanks for being here, John.
Yes, I don't know if you can start my video. It says that the host has stopped it.
Not sure. I'm not sure I know how to do that,
Yeah,
but we'll.
all
Oh,
right.
there we go. Okay, good.
Yes. Well, first, it's an honor to follow up two superstars in the legal field, and a tough act to follow from two great presentations from Howard and Lou. This topic, don't choke on the gag clause prohibitions, applies to group health plans. So if you're an employer and you have a health plan, this applies to you. Or if you're a health insurer, this also applies to you. Next slide, Kathy. And by the way, I'm senior counsel here, like Kristen said. I work in the employee benefits practice group. And here today we'll be going over what our gag clause is in your contracts, and how do you comply with requirements that prohibit those clauses. So first we'll go over background, over the legislative history of these kinds of prohibitions, who is subject to the requirements, what they are, how to comply, when your compliance is due, and why we have to do these compliance requirements. Next slide, please. So this all starts with a bill called the Consolidated Appropriations Act of 2021. It's a large spending bill, and it was kind of a Christmas tree bill. Everything gets thrown into it. It was $2.3 trillion in the end. Tucked in at the end was an act called the No Surprises Act. Its aim is to promote greater awareness of healthcare costs and quality of care information. In fact, to that end, it created a provision in both in all three of relevant statutes, the Internal Revenue Code, ERISA, and the Public Health Service Act. In all three of those acts, we now have a new provision that is called increasing transparency by removing gag clauses on price and quality information. Before we get into exactly what a gag clause is and what we have to do to prevent them, next slide, please, Kathy. Let's talk about who is subject to these requirements. There are two main categories of entities that are subject to these requirements: health insurers, people that provide insurance coverage to group health plans, and also to insurers that even provide individual health coverage. So it applies the whole gambit to health insurers. It also applies to group health plans, which can be plans sponsored by employers for a group of employees. It applies to both fully insured health plans and also self-insured group health plans. So you can be an ERISA plan, that's like your normal 401, it could be a 401k plan, a Medicare, but for these purposes, we're talking about health plans. So any welfare plan under ERISA, non-federal government plans, such as state or municipal plans, are covered by this requirement, and church plans. The excluded plans from this requirement are those that provides what are typically known as supplemental benefits, dental, vision, flexible spending accounts, also plans that are based solely on healthcare reimbursement arrangements like HRAs or ICRAs, which is kind of a new plan design of individual coverage healthcare reimbursement arrangements. Short-term insurance plans and federal plans are exempt from it. So now we know that what the scope of who this applies to. Let's go to what actually is required of them. So if we go to the next slide, Kathy. So there are two requirements that are associated with these relatively new gag clauses. So first, what is a gag clause? It's actually, that's the term that is used by the government agencies in their literature on this topic. And it's any sort of provision in a group health plans or health insurers contracts that restricts access to participants of the plans or to enrollees of a health insurance coverage option to access either explicitly or implicitly certain protected information. And so the relevant agreements for this type of requirement are agreements between plans and insurers with either healthcare providers, like an HMO, or third-party administrators, someone that handles your plan and handles the claims, or any other service provider that handles your day-to-day activities of your group health plan. You know, a lot of plans have someone like a Paychex or something like some entity like that actually manages the plan. Well, your agreements with all these service providers are subject to this gag clause prohibition. And so the information that is protected from any sort of restriction are basically three categories. The first category is you cannot restrict access to healthcare provider cost information, such as the price of care with a certain provider. You cannot restrict access to quality of care information for certain healthcare providers. You also have to make available de-identified, that means just redacted for the personal identifier information, such as a social security number. So de-identified claims data that is requested by participants of your group health plan. And this information, to actually be compliant, not only do you have to ensure that the provisions of your contracts do not restrict access to this information, you as the sponsor of your group health plan or the insurance company has to make sure that the participants or enrollees in your insurance coverage option have access to this information electronically or through quote unquote a consumer engagement tool, which can be like an application on your iPhone, something of that nature. And the government is construing this prohibition broadly. So it's not only prohibiting a term saying we are going to restrict access to this information to our participants, but also things that seem innocuous on its face, such as the plan has discretion to give this information to a participant. Even plans that have contracts saying they have discretion to give this protected information, that's a violation of the gag clause. They're going to say that that's you're gagging your plan from providing this information, and that's a violation of the law. And next slide, please, Kathy. And so the relevant agencies that are overseeing this this compliance with the prohibition on gag clauses are the Internal Revenue Service, the Department of Labor, and so the Health and Human Services Agency. So you got a lot of eyes on this issue, so it's important to make sure that you're complying with it. And the federal government is taking it so seriously that they are making every single group health plan and every single health insurer actually submit an attestation, basically swearing that they are in compliance with the gag clause prohibition rules. And every year, on or before December 31st, every group health plan and every health insurer must actually submit this attestation to the Health and Human Services, who's the entity that's going to be compiling it for all the relevant agencies. And you can submit it electronically. The website where you can do it is listed right there. When you click on it, you get the actual homepage. Well, looks like this this image here on this slide is the actual landing page, and you start to enter in the information. Next slide, please, Kathy. So now that we've gone over what the requirements are, who's supposed to comply with it, how do we comply with the gag clause prohibition and the attestation requirements? Well, for the gag clause prohibition, the first thing to do, and most important, is to review your agreements with your service providers and also with your plan administrator if it's if the plan administrator is someone who's in-house. And you want to ensure that there are no clauses that either directly or indirectly inhibit access by the participants or enrollees to the information protected by these rules. Regarding the attestation requirement, we're recommending, if you can, that either if you don't want to be responsible and keep track of knowing when to file, how to file, the rules allow you to hire a third party to coordinate the attestation filing. Now, there are slightly different rules and regulations for a self-funded group health plan. That's where the employer is paying the costs of healthcare for its employees directly, and for fully insured group health plans, which is when the employer has an insurance company that's actually covering the medical costs, and the employer, together with the employee, are paying premiums to the insurer. So for the self-funded plans, just consult with your third-party administrator to make sure that they are going to be. You can hire a third-party administrator. You can consult with them to make them file the attestation requirement for you. This is a service that they're starting to put together for all self-funded plans. But even if you make a contract with a third-party administrator to process your attestation filings, the group health plan still remains legally liable for any penalties that could arise from failing to file the attestation. So our recommendation is to insert indemnification clauses into that. For fully insured group health plans, both the insurer and the plan have to do it, but the insurer can actually do it for both. You just have to make sure that you make that clear to the insurer, and we also recommend that you get an indemnification clause for that. Next slide, please. The penalty for noncompliance is $100 per day per individual, potentially for all participants in the plan for the entire year. So it can be significant if you don't follow these rules. Next slide, please, Kathy. You got to, one of the last things is when to comply. The actual erasing of any gag clauses from your contracts actually went into effect in January 1, 2022. So please make sure that your agreements are all in compliance with that. And for the attestation, you have to do it every December 31st. Next slide, please, Kathy. And we did this to basically educate participants, to increase transparency, and to facilitate the comparison of coverage options, to make sure people don't get surprise medical bills at the end of the day. Next slide, please. So don't choke on these rules, even though they're complicated. Just review your contracts, file that attestation, and review your contracts to make sure that they are in compliance. And we're happy to help with that. And that's it.
Great. Thank you so much, John. Also just realized that we had your last name spelled wrong on your intro slide, and I'm really sorry for that.
That's
But on the next slide where we give our contact information, it is correct. So that is the correct spelling of John's name, because if you use the other spelling, the email won't reach him. But if you have any questions for any of our presenters, here are their email addresses. And I want to reiterate Kathy's request that you fill out a survey and give us ideas for future topics. We're always looking for ideas. Thanks for coming today, and we'll see you next week.
Thank you, everyone.
Thank you.